Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, estates, landlord-tenant, easements, and covenants. Let's begin. Real property becomes manageable when you divide interests into possession, future possession, use, and promises. Estates and future interests divide ownership by time. Landlord-tenant law divides possession by contract and property status. Easements give use rights without possession. Covenants and equitable servitudes make promises about land bind later owners. These doctrines are tested because they require classification, privity, notice, and remedy. The MBE follows majority modern rules, but still expects common law vocabulary. California generally follows modern landlord-tenant principles, including strong habitability protections, and recognizes easements, covenants, and equitable servitudes with recording and notice rules. Rule against perpetuities. Certain future interests are void unless they must vest, if at all, within 21 years after a life in being at creation. The common law wrap applies to contingent remainders, executory interests, and vested remainders subject to open. It does not apply to future interests retained by the grantor, indefeasibly vested remainders, or vested remainders subject to complete divestment. Landlord-tenant estates. A term of years ends automatically on a fixed date. A periodic tenancy continues for successive periods until proper notice. A tenancy at will can be terminated by either party. A tenancy at sufferance arises when a tenant wrongfully holds over. Easements. An easement is a non-possessory right to use another's land. It may be appurtenant, benefiting a dominant estate and burdening a servient estate, or in gross, benefiting a person or entity. Landlord duties. Delivery of possession. Under the English rule, majority, landlord must deliver actual possession at least start. Under the American rule, landlord need only deliver legal right to possession. Implied covenant of quiet enjoyment. Landlord must not substantially interfere with tenant's possession. Actual eviction terminates rent duty. Constructive eviction requires substantial interference, landlord fault or responsibility, notice, and tenant vacating within a reasonable time. Implied warranty of habitability. Residential leases require premises fit for basic human habitation. Tenant remedies may include withholding rent, repairing and deducting, damages, or terminating, depending on jurisdiction. Tenant duties. Rent. Tenant must pay rent unless excused. If tenant abandons, modern landlord must mitigate by reasonable efforts to relet. Waste. Tenant must not commit voluntary, permissive, or ameliorative waste beyond lease rights. Assignments and subleases. An assignment transfers the entire remaining lease term. A sublease transfers less than the entire term. Assignee is in privity of estate with landlord and liable for covenants running with the land, including rent, while in possession. Original tenant remains in privity of contract unless released.
Easement creation.
Express grant or reservation usually requires a writing satisfying the statute of frauds. Implication. Prior common ownership, severance, existing apparent and continuous use, and reasonable necessity. Necessity. Severance of title and strict or reasonable necessity for access, often landlocked parcel. Prescription. Use that is open and notorious, adverse, continuous, and uninterrupted for a statutory period. Estoppel. Landowner permits use, user reasonably relies, and substantial change in position makes revocation unfair. Covenants running with land. Real covenant burden. Writing, intent, notice, horizontal privity, vertical privity, and touch and concern. Remedy is damages. Real covenant benefit. Writing, intent, vertical privity, and touch and concern. Notice is not usually required for benefit. Equitable servitude. Writing, intent, touch and concern, and notice for burden. No privity required. Remedy is injunction. Wrap reform. California has adopted statutory reforms, including wait-and-see concepts, so common law wrap may be softened. On the MBE, apply common law wrap unless a modern statute is stated. On a California essay, mention California statutory reform if wrap is central. Residential leases. California strongly enforces habitability and anti-retaliation protections. Landlords must maintain basic living conditions, and tenants may have statutory remedies. A landlord may not retaliate against a tenant for lawful complaints or tenant organizing. Assignments. California often treats lease transfer restrictions according to contract language and reasonableness in some commercial settings. If the lease says no assignment without consent, determine whether the jurisdiction requires commercially reasonable withholding. On the MBE, traditional rule allows arbitrary refusal unless the lease says consent will not be unreasonably withheld. Modern trend limits arbitrary refusal. Easements by necessity and implication. California recognizes these doctrines, but will carefully examine intent, access, and whether the necessity existed at severance. RAP is tested at creation, not in hindsight, under the common law rule. If any possibility of late vesting exists, the interest is void. Class gifts create RAP problems. A gift to A's children who reach May 25th be void if A can have more children and a child might reach 25 too late. Constructive eviction requires the tenant to leave. If the tenant stays, argue breach of habitability or damages, not constructive eviction. Assignment versus sublease depends on duration transferred, not labels used by parties. An easement appurtenant passes automatically with a dominant estate, even if not mentioned, unless the parties clearly provide otherwise. A license is revocable permission, not an interest in land, unless estoppel makes it irrevocable. Negative easements are traditionally limited to light, air, support, and stream water, with modern conservation and solar statutes in some jurisdictions. When a question involves a land use promise, ask remedy first. If the plaintiff wants damages, analyze real covenant. If injunction, analyze equitable servitude. If both, analyze both. For burdens against successors, notice and touch and concern are crucial. For benefits, privity may matter for real covenants. For lease questions, identify the leasehold, the breach, and who is liable under privity of estate or contract. A landlord can usually sue the original tenant on the lease contract after assignment unless novation or release occurred. The assignee's liability ends when the assignee assigns away the leasehold, unless the assignee assumed the lease obligations by contract. Note: property essays are one with labels. Name the estate, future interest, leasehold, easement, covenant, or servitude before applying policy. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.